Attorney po, my mental health condition affects my performance. Can my employer dismiss me because of it?
Ladies and gentlemen, this question number 1 is actually 2 questions in one, no? Can the employer dismiss the employee because of the performance, the poor performance? That's the first question. And can the employer dismiss the employee based on the mental health condition? That's a separate question. Kaya nga, 2 question in one po yan. Punta muna tayo sa first question. Performance. Can an employer dismiss an employee who is performing poorly? At ang excuse or justification of the employee for the poor performance is, "Ma'am, sir, kasi po I have a mental condition. I have undergoing this therapy. I have symptoms like depression, anxiety, insomnia, and other symptoms, no? So that's why I cannot perform well." So yun yung kanyang excuse. 'Di ba? Usually may ano yan may feedback, no? You give the feedback to the employee, o bakit you're not performing well, what's happening to you, how are you, di ba? So ito ang excuse ng employee. Pagdating naman ng evaluation, pagdating ng mga feedback, bagsak, no? Failed, needs improvement, no? Ang kanyang performance appraisal. So how do we handle that? Can an employee be dismissed? Can an employee be terminated because of that, given that the employee already informed the employer na meron siyang health condition? The answer is yes. But we have to do it within the legal framework of Philippine labor law. Merong security of tenure. So ano po ang sinasabi dyan sa security of tenure? An employee cannot be dismissed. Hindi po tayo pwedeng mag-terminate ng employee unless there is just or authorized cause. Is performance a just cause? Is performance an authorized cause? Now, if we go by the labor code, if we look at the list, no, performance is not listed. Hindi po siya listed. Wala po siya dyan sa listahan ng mga just causes and authorized cause. Now, you may be surprised, no? But pwede po siya, no, the closest that we can find in the labor code is gross and habitual neglect of duty. May duty po lahat ng employee to show up, to attend, di ba, and to work. That's basic duty of all employees, no? To be punctual, to be present at work, to deliver, to render services. That's a duty. That's a basic duty of all employees. If you are being absent, if you are being late all the time, if you are being delayed, if you're not rendering your duty, that's a neglect of duty. And if you're doing that habitually, frequently, repeatedly, then that's an element. Pwede po magamit yan. And if the impact, if the consequences of this neglect of duty, this habitual neglect of duty is already serious, and it's really harming the employer already, then it is now a just cause. Now, another pwedeng gamitin, no? The Supreme Court in one case, in many cases actually, said that analogous just cause can also be, quote-unquote, gross inefficiency. Anong ibig sabihin nito, ng gross inefficiency, gross incompetence, or gross ineptitude? And how is this different from gross and habitual neglect of duty? Now, the difference is that the employee is showing up. The employee is going to work. The employee is perfect attendance. The employee is perfect punctuality. But in terms of the quality of the deliveries, kung meron tayong absenteeism, an employee who is nowhere to be found, meron tayong presenteeism, an employee who is physically present but is not delivering work in accordance with the reasonable standards of the business, reasonable standards of the employer, bagsak siya sa performance appraisal. Pag sinabi po natin gross inefficiency, yan po yung pinakamababang rating, ano? Talagang no improvement after giving the employee so many chances, so many opportunities, after training him, coaching him, mentoring him, and then allowing him to improve, talagang wala pong pag-asa. Yan po ang definition ng gross inefficiency, no? You've given all the chances. You've enrolled him in a performance improvement plan or PIP, pero wala pa rin, no? You've coached him, you've trained him, you really walk the extra mile at wala pa rin talaga improvement. Yan po ang tinatawag nating gross inefficiency, gross incompetence, or gross ineptitude. At pag nandun na po tayo sa point na yon that we did everything to support the employee, of course, no one can blame the employer. The employer would let go the employee. And that's considered as a just cause according to the Supreme Court, no? Okay, so ngayon, what if sabi ng employee, meron po akong mental health eh. May mental health condition ako eh. So again, we have to give the employee due process. The employee has to prove that he really has such a condition. Without proof, it's merely allegation, no? Pag hindi na substantiate ng employee yung kanyang defense, of course, ano pa ang pwedeng gawin ng employer? The employer has the prerogative to dismiss the employee. Now, ano naman ang gagawin ng employer if the employee can produce evidence